Okay, we're live.
Good morning, this is Senate Judiciary. It's sometime in February.
The 6th.
I think it's the 6th of February. And we're here this morning to talk about bail. And fortunately, our Senator Norris is out today ill. And so there's Senator Baruth should be here shortly. But let's see who the text is.
It's me.
Oh. I wanted to start out with just a comment. There's been a controversy here in the Senate over a budget adjustment act. And I know you're in education dealing with it. And the controversy centers around what you do with the cannabis sales tax. And because sales taxes automatically go into the education fund. But at the time that we were negotiating with the House and administration on legalizing cannabis sales and setting up a retail cannabis operation, we in this committee had purview over all cannabis bills, which I gave up after, because it's now more general, Bears Committee and government operations. But when we were debating the after-school programs, there was a agreement between the House and the Senate. The after-school programs were an important prevention piece, and that statistically, most kids get in trouble between 3 and 7 p.m. Not midnight, like one would believe. And it's because of a variety of reasons, which I won't get into. So we set it up that we were looking for innovative programs to deal with the after-school issues. And we also set it up to be both public and private institutions or programs. So for example, in my district, the Community Justice Center has an after-school program. It's called The Bridge. And, kids come there and do things they're not required to come, but there's a lot of kids that participate, particularly teenagers, in that program. There are other public schools that have programs. So we were looking for innovative programs, and we didn't want to restrict it to just education, even though it was education fund money. So that's how this whole controversy started. And then when they got this year in the Budget Adjustment Act, somehow there was an argument about whether it should be ed fund or a special fund. When we did, hindsight's 2020. We didn't set a special fund within the ed fund for the after school, but we directed that 10% or all the sales tax would go to the after school program. So that's where the controversy is. And I personally strongly believe that if you limit it to just going through education establishment, that, you lose the innovation anyway. So that's why I, as a member of the Appropriations Committee, strongly supporting the effort to try to make it clear that the funds are state funds and they're part of the cannabis revenue. Anyway, just so people are aware of the history of that particular dynamic, but I don't know how it got in such a battle in the House. But now it's here in the Senate, and it'll be part of budget adjustments. Yeah, obviously people are welcome to vote any way they want, but a lot of us have heard from our superintendents and principals and NEA and et cetera, et cetera. And I think it should be open to any group that doesn't discriminate. That's clear. If you're discriminating, we have a problem in Bennington County right now that it appears that, as you know, the high school for the northern part of my district is Bird, which is a great high school in my opinion. But some kids also go to Grace Christian School in Bennington, and there appears to be some issues there that have been raised by one of the the supervisory union, I guess, in the northern part of my district, that there is discrimination there. And so we have to deal with that. But I leave that to your education committee. And there should be no discrimination in any of these after-school programs. Anyway, that's my view. Happy to talk to you further. I know you're stuck with this controversy in education.
Yeah, a little bit. I won't go into the whole thing, but just on the piece of discrimination, it's part of the concern is that with the proposal, once the money goes out, there's no oversight as to how it's used for any of these groups. And the IDEA won't apply, the 2000 series won't apply, and so that's where I have part of my concern. But it would be a long conversation if I dove into all of it. But that's just.
Well, I'll leave it to the education and the health and welfare committee, but that's.
I just have a quick question, because I've certainly heard the noise around the building, but with you on the ed committee, there's nothing stopping that money, those nonprofits from getting that money from the ed fund, still with oversight as it is set up currently.
Correct.
Right?
Right now, the money can go out to LEAs who can and do partner with nonprofits and private organizations. So they are able to, and they have been able to, but they've withheld the money.
But we need to. Yeah, I think. Anyway, that's what's come up. So it does involve judiciary to the extent that we were the originators. So bail. We did bail 101, and we learned that we have an inefficient system.
Yes.
Full of opportunity for change. So let's change it. Do you want to start, Ben, with the amendment, or do you want to start with the? Okay.
Well, I'll give a brief overview of the amendment. But basically, it's a combination of H 195 and S 287, with no substantive changes, with the exception of moving two of the.
Do we have oh yeah.
Which one of these is that?
Oh, thank you.
This is the amendment we're over, and then this is just from 2018, the bail amendments from that. Just for reference.
Okay, so Act 164.
That was from 2018 that made the bulk of changes that I think the committee was interested in.
Yep. Okay, so you got a 25-page bill.
Well, a lot of it is just contains a lot of the statute for context that isn't necessarily being changed, other than some gender neutral terms and things like that. But if you turn to what is page 5 of the amendment, you'll see in subdivision 2, this combines what was in 195 regarding the number of offenses that the court can consider and whether the accused is, and I essentially combined or eliminated the second factor that's in 195 and replaced it with what's in 287 to consider whether the accused is subject to release on personal recognizance or subject to conditions of release related to protecting the public. In another case, whether they're subject to conditions related to protecting the public for probation, parole, and furlough, and whether the accused is currently compliant with any standing orders related to protecting the public. you'll notice that I did add a qualification to each of those factors, related to protecting the public. And the reason why is because, in bail, conditions are related to, primarily, securing someone's appearance in court, and then public protection factors come in second. And given the location of these additions, which is in subdivision A2, which is a concerning conditions related to public protection, that's why that qualification is in there, because I think it's especially important for court orders related to public protection, because there can be a lot of standing court orders that aren't related to public protection that you could then hold someone to account for. So that's a policy decision, but just with that in mind is why I added that.
Yep.
And
So
then,
that's a key change, right?
yes, from what was in 287 and in 195, in the sense that basically if there are issues related to violations that implicate public protection issues, then that's something that can be considered in imposing further conditions.
I have a question, Mr. Chair.
Sure.
So that was my question. It's, the new language is in a section that's headed in determining which conditions of release to impose. They will consider whether they already have conditions of release and whether they're currently compliant.
Right.
But there's no, as I can see, there's no penalty associated with breaking their conditions of release. It's just, will they get further conditions? But they've already proven they're not compliant with the ones they have. So let's say that they impose other conditions of release and let them go. I don't see how that gets us out of the situation that we're in.
Right, so the other part of 287 that was combined in this bill or combined in this amendment is that specific procedure.
Okay.
Which I'm just getting to.
Oh, I see, okay.
In due course. But if you go to page 9,
Got it.
this is completely unchanged from what was in 287. It's just combined in the amendment to 195 now, which is the procedure to violate the conditions of release, which starts on page 9.
So the page 5, we're allowing, or we're mandating that the judge or the officer take into account the nature and circumstances, all these other things, including whether they're currently breaking conditions. But then as a separate matter, there's the ability to find violations of conditions of release.
Exactly.
Okay.
And it's essentially a summary procedure where if someone is cited for it, they have to appear within the next business day. And I can go through it again, if the committee would like.
I think my wish is to go through the violations and see where we're at. Section 7554E on page 9.
Okay.
Let's go through that and then come back to how that fits with what you did in subdivision 2 on page 5.
Sure.
I think they work together.
They do, yeah. If someone were to violate those conditions, this is how they can be held to account in a quick way. So essentially how it's proposed right now is that there is an arrest, citation, and appearance provision. So anybody who's alleged to violate a condition of release may be arrested or cited to appear in the same court in which those conditions were ordered. A judge has the ability to issue a warrant for arrest for someone that violates conditions. And then, excuse me, the person must appear not later than the next business day following the arrest or citation for a summary hearing pursuant to subsection B of this section. Subsection B outlines the hearing.
Sorry to interrupt you. So, so the flash site for violations of conditions of release is based only on if there are multiple violations of conditions of release that's listed on page 5. Is that the connection there?
Well, not just multiple, it can be a single one.
Got it. So
Yeah.
all conditions, all violations are flash cited now in this context?
Yes.
For this language? Okay, thank you.
You know, up to the discretion of the, you know, law enforcement prosecutor, obviously.
Thank
So is there somewhere in here where we distinguish those released on their own recognizance without condition?
Well, normally there is always going to be some sort of condition, you know, typically it's, you know, when people are released on.
Most people are released on their own recognizance.
Right, but
Condition.
the stock condition is come to court when you're supposed to, you know, keep your information up to date. So I've never seen or understood that there's no such thing as conditions, whenever someone comes to arraignment. Now, bail is a different story. But you can be released on your own, just with the condition that you come to court when you're supposed to. Yeah, but if you do want to account for the circumstance, which may exist, where someone is truly released without any conditions, you know, including the condition to come to court, that can be drafted into this too.
Well, I'm thinking of person's arrested for a minor misdemeanor is cited. I should not have used the word arrest. Is cited to come to court 3 weeks from the time that misdemeanor happened.
Mm-hmm.
So there's no conditions during that 3 weeks. You just go to court on whatever day you're directed to come.
Correct.
So presumably, there's an opportunity there to divert, to do whatever we do in the criminal justice system.
Mm-hmm.
That's different from the person who's arrested and then has to appear in court immediately following the arrest, or the judge sets bail or doesn't set bail, whatever they do. I mean, I know a lot of people are arrested on Friday night, they go to jail for the weekend, come out, then they're released on condition.
Right. I mean,
I want to make sure we distinguish that two groups, those that are cited, because obviously those that are cited.
well, they still come to court.
Right.
Yeah, and right now, you know, as far as like diversion is concerned, they're still gonna, you know, what a judge does is, you know, they have their own practices. Some judges will require the person to actually sit through the arraignment and then say, okay, go meet with the diversion coordinator in the next room and give the packet. Some judges will just make a finding of probable cause, send the packet out, and they don't even necessarily have to formally appear, but they'll just go to meet with the diversion coordinator
Maybe I'm
before.
overcomplicating the difference between citing and arresting.
Perhaps, you know, with a citation, I mean, you still are cited to come to court. You don't, for that period, but this can happen with an arrest where you're arrested and booked and then you're released and you still are given a court date, you know, maybe in a couple weeks to go for arraignment. So it can happen in multiple ways, but for that period before you have to appear at arraignment, there aren't going to necessarily be conditions.
If you're cited to come in 3 weeks, that when you're cited, that's when the judge might set conditions.
Correct.
So you're shoplifter, cited, come back in 3 weeks, then the judge can set conditions that you no longer shoplift.
Right.
Like folks.
Yeah.
Or whatever other conditions. Okay. So once you've got conditions of release, then we deal with violations in this section.
Correct.
Okay. Sorry.
No, these are good questions to ask. So moving on to the hearing procedure. So someone comes to the hearing, and the judges to make the determination whether the allegation of that the condition was violated was true or not. So there are various factors that the judge must consider in making that determination. One is whether probable cause exists that the person committed an offense under federal or state law while subject to those conditions. whether clear and convincing evidence shows that the person violated a condition, and further finds that based on the factors set forth in 7554, which, going back to those conditions from before that we were talking about adding, that there is no condition or combination of those conditions that would reasonably ensure the person's court appearance, mitigate the person's risk of flight from prosecution, or reasonably protect the public, or the person is unlikely to abide by any condition or combination of conditions. So those are the things that the court must consider, and for those last two, by clear and convincing evidence. So it needs to be solid, reliable evidence, not just probable, that there's no condition or combination of condition, or that the person's unlikely to abide by conditions.
Ben, so I'm looking at lines 7 to 8 on page 10.
Yes.
Which I think kind of illustrates the heart of the issue that we're trying to revisit, which is when these orders are issued, there's really no enforcement mechanism. And what I'm seeing in that language is that if it's found that an order is violated, regardless of whether there's a flash site or not, the response to it is to issue another order. Is that accurate?
Right, and they can have greater conditions. It's also and we'll see that if there aren't any conditions that are, that the court determines that would, secure their appearance or protect the public, then jail is a possibility.
So,
Thank you.
Mm-hmm.
would at this point the judge have an opportunity to make orders? The person's condition of release was that they obviously want to not commit more crimes.
Mm-hmm.
And by clear and convincing evidence, we determined that you committed this new crime. Does the judge have an opportunity to say, all right, you're not, the judge have an opportunity to offer alternatives to jail, such as residential treatment, such as counseling, such as whatever.
Yeah, and then they have the opportunity to potentially do that right at the outset. But this would provide another opportunity.
They didn't. You'd still have the opportunity to offer the person choices of treatment or.
Yes, this does not preclude them from offering those. It actually provides another opportunity to do that. And there's a little bit of a track record at that point within that case to really look back and see.
So you were ordered to go through a drug screening.
Mm-hmm.
You failed to do so. Now we've got you on driving while drugged. And instead of putting him or her in jail, there's an opportunity to say, if you will agree to go to treatment, here's a treatment counselor right here.
Mm-hmm.
And Joe Smith is gonna monitor your participation.
Yeah, they would have the ability to provide any condition that's relevant. So if they were to agree to that, that's a possibility.
Yeah, I just want to make sure we're not saying if you violate, you're automatically in jail, but you're getting closer.
I'm jumping ahead a little bit, but my question's about the disposition of violations on 11,
Mm-hmm.
which is if they determine.
Okay.
Yeah, I'm just kind of going through it.
Okay,
But yeah, I'm happy that.
I can wait.
No, go ahead.
Okay, so if the judicial officer finds that there is no condition or combination of conditions that will reasonably ensure the person's court appearances, then they can be committed to the custody of corrections, detained, and then on 12, it goes 14 days, 30 days, third is 30 days, and fourth is any amount of time, but not less than 30 days. So I have two questions. First is, we pass this, it goes into effect, there's somebody who already has proof that they violated conditions twice.
Mhm.
So does that count as a second violation or a third if they come up? Or is it from the effective date? Does that
Well,
make sense?
It would
This was
traditionally
part of
be,
the bill that we're putting in here, and
Yeah.
whether or not, the discussion really is, do we want to accept all of that bill?
Yep,
And this directive of the days, I think, was part of the,
and
but you're saying if there's an ongoing
I think
case,
this is
Yeah.
Senator Brock's bill
it is Senator Bragg and Norris.
and Norris, so
Um,
I'm not sure we want to be that prescriptive.
but typically, once, legislation's passed, it would apply going forward.
But if this was,
But,
right,
Yeah.
it would apply that you,
but that could be written in, it's been done before, to make it clear that if there's someone currently on conditions that may have had, one or two
Mhm.
violations and now they're subject to this, that basically the clock only starts once.
understood that this is a bill submitted by one senator, and we're looking it over. But am I wrong that on page 12, when it says any amount of time, but not less than 30 days for the fourth, it could literally be any amount of time, like,
Yeah, just
10
not,
years.
just not less than a month.
But could they say like 10 years in that context?
It's possible.
It just seems kind of weird.
But, it would have
Especially
to
given
be,
that it's pre-adjudication.
I know.
Right.
I know.
but, again, it has to be subject, there are due process requirements just inherent to any determination like that. And it would have to be, it's couched in the rest of the qualifying language, in terms of necessary to assist
Yeah.
in the management and behavior of the person. But yes, if hypothetically, if
Yeah.
for some reason they think 10 years is necessary, but,
Okay.
Yeah.
Thank you.
Senator,
I mean, my question is about that same piece and whether it is sort of a potentially unconstitutional workaround to the space that says you can't hold someone without bail unless they're a danger to the public, and now we're saying, actually, you can, you just use this. Does my question make sense?
Right, and, part of the due process consideration is that it's balancing public protection with an individual's freedom, right? And that's why the public protection qualification with those additional factors, that's partially meant to address that concern, is that you're not just, there has to be a risk to the public, and that's what we're balancing here. But there's also another hearing, so there are due process, at least procedures worked in. But to your point, yes, it does raise the question about whether or not substantively you're essentially adjudicating someone before they've gone to trial.
can I ask Don, well, not Don, I don't ask Don a question.
You do not.
usually. If we struck A, B, C, and D, and went right to, actually strike 3 too, as 3 as well, and went right to to line 14 of page 12. The court may revoke bail and hold a person without bail when the person violates commission issued in this case, without being prescriptive and setting mandatory minimums. I mean, we wouldn't set a mandatory, we usually don't set mandatory minimums. And here, it seems to me, we're setting a mandatory minimum on somebody who violates conditions of release.
But if we were to do that, and correct me if I'm wrong, it seems like then we're limited by what the original case would have been, rather than the fact that they've now violated conditions related to public safety. Because this language points you back to what could they have originally been held without bail, and that'll never change, no matter how many conditions they violate or how much public safety they have.
I don't know.
I mean, I think at a certain point,
But could that, so if we don't do A, B, and C, what's the impact?
Well, you're still holding them, at that
The
point.
judge is still able to hold.
Right.
Just not a determined.
And with this one, are you saying eliminating the, cross-reference to 7553 and 7554A, or just to keep 4 altogether? Because that limits it to just those serious crimes, a violent crime or one punishable by life imprisonment. So that's what 4 does.
Okay. Well, I'd like to have the ability to hold without bail for a repeated violation if the court wants to, right?
Well, and that goes to, there's the revocation of bail statute in 75, 76. Excuse me, I can't remember exactly off the top of my head. Yeah.
Question. I just wonder all I'm suggesting is that I'm not comfortable with A, B, and C.
I agree with that. I guess I have 2 questions. The first being, there are circumstances, or rather, so there's judicial discretion, and are there circumstances where the standard could be met for 7553 and the judge says, we're not going to hold this person anyways?
Yes, I believe 7553 still retains, that's a statute that retains the judge's discretion. So yes, there is that.
Yeah, and so I think I don't like mandatory minimums, but I mean, the thing that's coming to my mind are, if somebody is repeatedly committing simple assault or domestic assault, which won't fall under 7553 or 7553A, what mechanisms are in place if somebody gets arrested the first time for simple assault, a few hours later they get arrested for domestic assault, and now they're really pissed and they go and commit another simple assault. That's what I want to try addressing, and I know that those misdemeanors won't fall under 7553. So that's, for me at least, that's what I want to try getting to.
Yeah, exactly.
So when I look at that subsection 4, maybe I'm misreading the language, but I see the part we're talking about where it's related to the original crime. But beginning on line 16, I also see or commits a new criminal offense while a case is pending in which the person could be held without bail. Wouldn't that get to if they're on bail for a crime that they couldn't be held, but now commit a crime where they can be held?
Well, but it's still qualified by that.
Still the original threshold.
Yeah. So the way it would read is that the court can revoke bail and hold the person if they violate a condition of release in a case where they're already, that implicates a violent crime or crime punishable by death or life imprisonment, or commits a new crime that qualifies for that. So it violates a condition while, in a court case for that violent crime, or commits a violent crime while they're out on conditions.
Right, but in the instance that Senator Hashim just gave, a new domestic assault would be a violent crime, yes?
There's that clear and convincing evidence standard. Guilt is great. There are a whole lot of standards that you need to make to get to that point. So theoretically, yes, it could be.
Okay. Thank you. I thought I was misreading that. And I think if we're talking about taking someone's freedom away before they've been convicted of a crime, there should be a high threshold.
And there is in this case.
Yes.
Yeah.
But it does not bar you if you meet those criteria in a new crime that was a violation from then holding them without bail.
Correct.
Okay, thanks.
Holding them without bail for a felony.
Yes.
Okay.
So I can continue on.
If right following that is contempt.
Right.
And I'm just wondering if you can, would it be regarded as contempt to violate your conditions of release?
Well, that's a good question. So contempt is, there's a procedure under Rule 42, the Vermont Rules of Criminal Procedure, which is essentially holding somebody in contempt. And it's if you're, essentially flaunting an order of the court to such a degree that you can be held in contempt. I mean, so theoretically, yes. So they have another mechanism currently to do this. But, as far as its effectiveness and why it works or why it doesn't, I would say, ask the practitioners
Yeah, because the example that Senator Hashim gave seems to me like contempt. In other words, somebody just committing crimes willy-nilly regardless of the conditions. That seems to me inherently contemptuous of the authority of the court. And I don't know if that's a place to locate the new detention possibility.
And in that bail revocation statute, that the number escapes me at the moment, they do have, bail can be revoked for repeated violations of conditions of release that impede the prosecution. And that was added in Act 164 in 2018. And that was largely mirroring the constitutional case law that basically says, yeah, you can have a bunch of different violations, but you can't have your bail revoked and held without bail unless it seriously impedes the prosecution. So that's the catch.
Not public safety.
Right, but it could implicate that. But the examples that were given in the case is that essentially if you're tampering with witnesses or threatening them, so that does bring in the public safety, but it's really something that makes it so you can't prosecute the crime anymore. So public protection alone may not be enough.
My understanding is that what that provision you're describing is rarely used because of how, I guess, unclear it is in the case law. And I don't have the information right in front of me, but I guess this is a comment for, when we hear from the state's attorneys and defenders on it. But
well, there's the State v. Saab case, which this was kind of derived from, and there's a difference between the statutory language that you see in that bail revocation statute and the language from that case. In the statute, it says impedes the prosecution. In that case, it says disrupts the prosecution. And I think there's a bit of an academic exercise to undertake, say, well, what's the difference between an impediment and a disruption? I know that I've spoken to state's attorneys here that view impediment as a higher standard than a disruption, because impediment is really something that prevents it.
Impediment would be intimidating a witness.
But a disruption could be
yelling and screaming at the judge,
or not appearing in court,
But
they do give some examples of that as well.
Where was it? Somewhere after telling the judge that he learned his lesson, the guy jumped.
Oh, it was in Nevada, I think.
Oh, yeah. Because he was trying to show contrition, and then when he sentenced him anyway, he jumped him. Jeez.
Right.
He learned his lesson.
So I guess to round out this portion at least, so subsection E just makes it so that it's clear that you can still use the contempt procedure in addition to this one.
Good.
And then if you go through section 4, repeals 7559, because this is sort of right now the mechanism to bring people into account. And you can see here, if you go on to page 14, beginning on line 6, subsection E, there's the cross reference to Rule 42 of the Vermont Rules of Criminal Procedure, which is the contempt process. So basically, we're just saying that still goes into place, and then the mechanism that previously existed is now struck in preference for the bail violation procedure that we just went over. And then you'll see here on page 15, a change to the definition of flight from prosecution. So flight from prosecution was added in 2018 as a defined term and replaced to ensure securing someone's appearance at future court proceedings, and now defined it to be flight of prosecution or from prosecution means any action or behavior undertaken by a person charged with a criminal offense to avoid court proceedings, and now adds including non-compliance with court orders related to protecting the public and failures to appear at court hearings. So those would then automatically be subsumed into that definition. So people who don't appear at court, appear at court can now have, conditions, related to that, for bail. This connects it to bail, not just for protection of the public. So those failures to appear at court hearings and non-compliance with court orders are now considered, this amendment would connect it to bail, which is securing those appearances. And it is an expansion because the non-compliance with court orders, there are court orders that may not be related to, appearing at court, like ones that are related to protecting the public.
Ben, quick question. I know if you can refresh my memory, there's a case that answers the question as to whether or not non-compliance with court orders actually do fall under flight from prosecution. And do you remember what case that is, or what I'm?
Not off the top of my head. I'd have to.
Because I know it's been brought up as whether or not violating a condition equals a risk of flight.
Well, it might be that solved case.
Yeah.
Which is that bail revocation case again. I'll double check and get back to you.
Thank you.
All right, section 6.
So sentencing alternatives. So this now, a judge, you get to the point where you're sentencing someone after they've gone through trial or if they've agreed to a plea. You'll see on line 14 that one of the considerations that a judge makes would now include any violations of conditions released by the defendant. So that would be something considered in sentencing, which is not currently explicitly stated here.
So this is at the sentencing after the person's found guilty?
Or please.
You could consider violations of conditions of release.
Yes.
In sentencing. Okay. But it's, at some point, we should talk about alternatives to incarceration while somebody is on conditions of release. Mm-hmm. These are sentencing. I thought when we did the 2018 law, we had alternatives to consider. The judge could consider certain alternatives.
Well, there are the standard form conditions, and there are, conditions that contemplate alternatives to incarceration, like being under custody of a responsible adult and things of that nature.
I'm going to say home detention would be an alternative.
That would be. It's currently not under the current structure, not
supervised curfew would be an alternative.
Well, and that's permitted now. You can have
let's get that into this bill. Because I think we need to make clear that the legislature, the reason we're doing this is because people are upset about violations of conditions of release and nothing happening. So it should be clear what those alternatives to incarceration are.
GPS monitoring.
I was hoping that the House would pass something on how home detention that was monitored. I think that there's only like 12 people.
Yeah, it's very few. I know it's fluctuated, give or take around 10.
So there should be 1,000. Well, maybe not 1,000.
Maybe not that many.
Well, it should be more than 10.
Agreed.
So Senator Steers, I have a question on that with home detention, because right now that's limited to people that are subject to bail, are unable to pay bail, and have been detained for 7 days or more. So you want to change that threshold requirement?
Yes.
Okay. Do you have just for anybody that it would become a standard condition?
The court determines would benefit from that level of supervision based upon whatever clear and convincing evidence standard. That they could be,
So roll those into the violations section that we just went over.
These are the alternatives that the legislature is trying to put in place. Supervised detention, supervised curfew. Could be supervised by a responsible adult, I suppose. Could be, yes, Senator, I'm talking off the top of my head.
Oh, my question was about that home detention, and sort of how that's structured. If I'm released to home detention, am I allowed to leave my home to go to work, to
Yes.
visit my kids?
Yeah, you have
Yeah, they're a pre-approved,
basically an
schedule.
ankle monitor,
Okay. If
Yeah,
I
but it's,
cut my
right,
hand and have to go to the emergency department, am I
Medical,
going to immediately be
it's
arrested?
basically court, work, medical, school.
currently, it's passive.
Yes,
And part of the problem is because it's passive, person could commit a series of crimes for the and go places, and whoever's looking at the ankle monitor computer printout is not seeing it. Maybe they see it maybe the person does it on the weekend and they don't see it until Monday or Tuesday.
and that was a change that was just added this past year to
Right.
permit passive monitoring, and that was in response to, the department was going to eliminate the home detention program. Because there's testimony that it's pretty staff intensive to do that real-time monitoring. So they essentially testified that the only way to keep it ongoing would to have that passive monitoring.
I've
so you
had
don't have.
conversations with Sheriff Clark, who would be more than willing to start taking over that.
Yeah, and I think that's part of the policy consideration.
Not Sheriff Clark was the one who started it in Wyndham County. And Sheriff Anderson is willing, I'm sorry, Sheriff Anderson, I used the past.
Yeah, and I think it was department staffing that was, and
Right.
part of,
Once the sheriffs were taken off of it, put into the department, that's when.
and that was one of the things that Justice Oversight sent to,
Right.
in their memo, to explore
And the House,
really who should be
right.
responsible.
Yes. So I'm happy to start a pilot project again.
Okay. With the Department of State's Attorneys and Sheriffs,
Anybody who's
or?
willing. Any company that's willing. Massachusetts can do it. Seriously, Massachusetts does it. It's only looking at an ankle monitor and then notifying law enforcement that the person's out of bounds. So
So basically allowing the department to contract with a private entity.
yeah, for sure. Obviously Sheriff Anderson is interested. It worked well.
Okay.
That a person from Sheriff Clark had a relationship with the sheriff of Bennington County, so they both did the home detention. A guy who was convicted of domestic assault was placed on home detention instead of, was charged with domestic assault, placed on home, fairly serious, placed on home detention with the agreement of the victim, who was his wife at the time, was a truck driver for a furniture company that was located in Bennington, but they also had a Rutland. So the company agreed to transfer him to Rutland, kept his job, paid child support, did all the things he's supposed to do. And it was fairly successful because the outcome was, if he'd gone to jail, he'd have lost his job, unable to pay child support, et cetera, et cetera, et cetera. So I think home detention is a great alternative. I also think that, you know, you can do supervision, and that's where we come in the later stages here. We can talk about that proposal.
But weren't there technological issues with the ankle bracelets? No?
I don't think so.
I thought there was a GPS, or,
Well, I think
Signal.
you had to be, yeah, I think that might have been one.
so it would get tripped by losing the signal through no fault of the person wearing
But
it.
now the ankle bracelets, in the case of domestic assault, the victim can be handed out. So the victim knows where the person is too.
Huh. That's interesting that we're giving, I mean, for a good reason, but we're giving people, citizens, the ability to track other.
Well, I think you have to be the victim.
Well, that's what I mean, but even so, I'd never heard of an instance where we enabled somebody to track someone else.
They do now.
Huh.
They know if they get within a certain distance of the victim. I don't know that they know where the
Do you mean the police know, or the
the
victim?
victim knows
Oh.
if, let's say, the victim goes to the hospital and the assailant is also at the hospital. They would know that.
So they have a device that tells them where the person is?
I think, I'm not sure how much information they get. I don't think they get information that they only get information when the person is close proximity.
Okay, I'm sorry to delay this, but
That's my understanding.
Meaning-
We'd have to get somebody that understands. it.
meaning that they get a text saying the person is.
Probably.
Okay, that's a different thing. I thought you were saying they had a monitor that allowed
I don't
them.
think so.
Okay.
They may.
That would be weird.
I mean, we all kind of have a monitor.
I mean, I marveled, I was watching the arraignment of Aaron Hernandez, the former tight end for the Patriots. You know, the way the district attorney was, we know he was here. You know, it pinged in Boston, it pinged such and such a street, all the way to North Attleboro, where the murder occurred. And he voluntarily carried that.
Yeah, well, and even if you don't have that system, just your cell phone, like I'm thinking of the guy who is alleged to have killed all the people in that house.
Yeah.
Out west, and they went back to his cell phone records where he was, and they have him driving by the house constantly.
Yeah.
So I guess, Senator Bohofsky's right, we're all carrying a GPS.
We're all carrying a GPS device.
Yeah.
Pretty soon I'll be able to follow you, Senator Coolidge.
I'm surprised you're not already.
I was gonna say, if he allows you, you already can.
Well, I need to get access to his telephone record.
Yeah.
Which is important.
I never put it in the phone call.
Anyway,
Okay.
so we're at sentencing alternatives, and we adding any violations, conditions, or rules.
And Senator Sheen, I think, I just quickly checked that state visa case that you were, that I think this gets at, it says that a person may repeatedly violate court orders and commit crimes similar to that with which they are charged. Such flagrant disregard of conditions may show disrespect for the judicial system, but these violations do not necessarily threaten the integrity of the judicial system in the constitutionally limited sense that they thwart the prosecution of the defendant. Says that it goes on to say that the courts have recourse to deal with that, which is including more stringent terms and of release and initiate contempt proceedings. But the one sanction not available to the court is withholding the constitutional right to bail itself. But, bail and conditions, they're related, but have some distinctions there. But basically, the bottom line is that if you do want to hold someone, there has to be a legitimate and compelling reason to do so. So that's sort of the balance that they're striking, is that they do want to say that there may be some constitutional exceptions to hold someone, but it has to meet that compelling and legitimate standard.
So as I'm understanding it, then would multiple violations not fall under flight for prosecution based on that order or that opinion?
Currently, that's correct, but under this bill, they would be included in flight from prosecution.
So it would, in a way, be kind of backpedaling what is in that opinion, or
Right.
modifying what's in that opinion.
But I would flag for the committee that just because it's added to statute does not necessarily make it constitutional.
Right.
So there would still inevitably be something to be worked out within that.
Would you go down to the Supreme Court and ask them?
Sure.
Send a quick text.
They're always receptive to that.
No advisory opinions.
I jumped ahead to the firearm section.
No, I did too. So in section 7, this amends 18 VSA 4253, which is the use of a firearm while selling or dispensing a drug. So what it would do here is that it would add, for the definition of use of a firearm, it would include carrying or possessing a firearm, which is different than the current statute, which is the exchange of firearms and only applying to someone who trades it. So an actual
That's
sale.
the straw purchases, which we did, was it last year?
I believe so. And then this adds a new subdivision D that would make the use of a firearm a violent act for the purposes of determining bail. So that then brings it together with that public protection aspect where you can separate it from.
I'm kind of. Use of a firearm includes carrying or possessing a firearm. And we always hear from the Federation of Sportsmen Clubs and others that everybody well, not everybody, but people have a firearm on the window of their pickup truck. Does that constitute carrying a firearm? I have to ask. Was Senator Brock's intention to?
That I can't speak to the intention on that one. But I think that there's a reasonable argument one way or the other. I would need to do some more research exactly on.
I'm not sure that has been, because we're saying now that's a violent act, right, for purposes of this section. And I know that always comes up when I propose it, or Senator Baruth proposes something like that.
Yeah. You could say carrying on their person.
Senator Valsky.
Yeah, I had concern with that as well, especially the sort of possession piece, because that could, and this is gonna come as no surprise, particularly it's linked to the dispensing of a drug, because that might mean that I have a firearm in my bedside drawer, I share a drug with someone, and now I'm being considered violent. You know, I probably should.
Maybe you should use somebody else as an example.
Perhaps I should use someone else as an example. Senator Hashim. If someone is at their home and they own a firearm and they have a substance that is illegal under our law and they share it with that person, because dispensing is included, they now could be considered violent. So I also have concerns with that.
I think the traffic, I agree with Senator Valsky, folks.
You agree with me there,
I know. I'm kidding. I think we should take out the dispensing. We're really getting after drug trafficking, and I think that's something that I would agree with. And then I agree with Senator Baruth on I'm not sure we want to go all the way to carrying. But if you take out the dispensing, it makes me more comfortable, because they're a trafficker with a gun in the back seat of the car.
All right, so I could
leave that alone by taking out dispensing.
I'll remove dispensing from subsection D and then explore carrying a little bit more. Maybe.
Yeah, I just make sure that, well,
I'll talk to Eric too.
Yeah, I talked to Eric and we've been through this before because, as you can imagine, and I think I will speak to Tim Meehan about it too. Let him know it's in there, they have concerns. But by taking dispensing out, I think you made it, we're only drug traffickers.
Mhm.
Tell Tim he has to take it up with Senator Brock.
Yeah. And Norris and all the others.
Take their guns away.
All right,
So if we're ready to move on to section 8,
Yep.
Essentially section 8 makes it so that repeat offenders can't be a part of diversion. That's essentially the one change of this portion, and it's on page 18, line 16.
what is the Tamarack program?
Tamarack program is for adults that have substance use issues.
Right,
Yeah,
but they're second, third, fourth, they're repeat offenders.
yeah, they can be. There is a qualification for them, but
Would this nullify a Tamarack program?
no, because Tamarack's separate from diversion. It can be related, but it wouldn't necessarily
My
nullify it.
diversion program runs the Tamarack program.
Well, right, they may be, the provider may be running it, but it is technically a separate program.
Senator Bowles.
So one, I think we need to hear from the restorative justice practitioners about this. Two, I have significant concerns with this, given that it doesn't account for desistance and the fact that someone may be a repeat offender, but lowering their level of criminal engagement over time. And we know sometimes it takes multiple times for someone to get all the tools that they need to go out. So I have huge concerns with this section. But I would also want to hear from our RJ practitioners.
Well, I'd like to hear from the state's attorneys too on this. So could you make a note of what we're talking about? Of who we'd like to hear from? Because I think they like the discretion of being able to divert people on a second or third, sometimes offense. How does one define success?
It's a question they're dealing with in the House Judiciary right now on H645.
On what?
On, regarding diversion and pre-charge and what does it mean to successfully complete the program?
We can't, I had a boss who was philosophical back in the day. Said you can't define success, you can't tell somebody was successful or not till they die. Because,
Oh, because they could fall off the wagon today.
well, Rudy Giuliani,
Yeah.
America's mayor, look at his legacy now.
Yeah.
He also said that, is it a success if somebody stole 50 cars a year and then was down to 1 a year?
In a sense,
Is that a success?
success for the community.
But anyway, that's what. But if you think about that, to try to define success, we use recidivism, we use all kinds of terms, but we never really. Anyway, obviously noting that this section needs further.
Right, and you'll see here again on page 20, lines 10 and 11, again, the restriction on repeat offenders that each state's attorney in cooperation with the AG and shall develop clear criteria for deciding what types and what offenders will be eligible. State's attorney retains final discretion, but repeat offenders are completely excluded from it.
Isn't that kind of contradictory? If the state's attorney has final discretion, how can we take that discretion away?
Sure, the state's attorney may have something to say about that.
Maybe it's in
And then moving on, again,
I just want to bring an example of this. So if a person had one try at diversion are they not eligible because the case, or let's say it was a case that got expunged because it was, what do you call it? It's not diversion, but it's deferred sentence.
Hmm.
And so after 3 years of not being in trouble, the case was dismissed, expunged. And then year 5, they get in trouble. Are they a repeat offender?
Well, I would say that if their files in case were expunged, it wouldn't like the system wouldn't view them as a repeat offender because there wouldn't be any information available to them. But I think what the ultimate point you're getting at is a repeat offender in this context is undefined. So that could potentially include people that have never been adjudicated of a crime but have gone through diversion and maybe succeeded completely, whatever success meant.
Yeah.
Or someone that was convicted and then maybe had to do some reparative work or whatever. It could include everyone. But
Every youthful offender is a deferred sentence, technically.
right, I mean, yeah, with youthful offender, it's different than a delinquency.
Right.
Yeah,
But it's a deferred sentence that could be brought in a period of time, and then
right, if
they don't get into further trouble, then.
correct. Yeah, because they could ultimately be convicted if they don't comply with the deferred sentence
I'm
requirement.
not sure we're gonna keep this section, but if we did, we need to account for what is, I think you need to define what's a repeat offender.
Yeah, and I would say that that's a policy consideration for how you
Well,
want to
no, I
define it.
agree, but if we were to keep this section, I think we have to have a definition of what a repeat offender is.
Well, that can be done. And section 9 is essentially a report on referrals, restorative justice referrals. So this would create an annual requirement on or before the November 15th of each year that the Attorney General, in consultation with DOC and the restorative justice providers, submit a report to various standing committees, including this one, examining the referrals to diversion and other programs and services employing restorative justice principles. The report shall include data on the number of referrals by crime type, the number of first-time offenders by crime type, the number of repeat offenders by crime type, and the number of times an individual has been referred to the same program or service and for which crimes. And then there's data sharing requirements that basically the Attorney General's office will get the data they need to compile
The
the program.
administration has begged us not to add reports.
This is the Attorney General, not,
Yeah, I know, she's got the money.
yeah.
I don't think.
Well,
I really think we should be careful with reports.
And this is something that came from 287, so from, Senator Brock and all.
Right, I understand, but I think we should be, I'm gonna try to be careful about, particularly annual reports.
Mhm.
Senator Bowles.
I also wonder how much of this information was already captured in the big criminal justice reporting bill we did last year.
I think there's definitely some overlap.
I thought so as well. So I agree, I think that we wanna.
It may not be as specific as it's outlined here, but crime type reports, repeat offenders, evidence of desistance, there's definitely a lot of overlap between what's being attempted to be collected here and what S4.
Given that we're on YouTube, I should have agreed with you that the Attorney General is overburdened as well, and would prefer not to have a lot of reports.
Especially not duplicative reports.
Especially not duplicative reports. I don't think this report is gonna survive. I would
Okay, well,
suggest that a redraft would take the report
I
out.
can strike that.
Sorry, Senator Brock. Senator Norris is not here to,
Defend it.
as a co-sponsor of the bill.
And then the final section, outside of the effective section, effective date, is the creation of 6 positions within the Department of Corrections. 6 new permanent classified pretrial supervisor positions within the Department of Corrections. Basically, in addition to any duties deemed appropriate by the department, they would have a few duties when it came to supervising pretrial releasees. 1, to collect, verify, and report to the court prior to arraignment or bail hearing information pertaining to the pretrial release of each individual charged with an offense, including information relating to any risk the release of such person may pose to the public and any recommended conditions of release. This is modeled off of the federal pretrial statute and what their supervisors do. In addition to that, supervise individuals who are released on bail or personal recognizance and subject to conditions of release as ordered by the courts within a region of Vermont designated by the department. To educate individuals who are released on bail or personal recognizance on the resources available to them. So including drug screenings, substance abuse treatment options, things like that. And then report to the courts in their region on any individuals who are released and have violated any conditions of release. And then they'd be subject to an appropriation from the general fund in fiscal year 2025.
I asked Ben to include this section.
What I would suggest on top of this is that this creates the positions, but it doesn't necessarily create the program itself. So that would be a necessary addition, but I wanted to flag that I didn't want to necessarily just go ahead and do it without having some guidance, but that's something that would need to be created either within the department itself, maybe an office of pretrial services, or however you would envision it.
That gets at one of my questions and might actually answer my other concern. I agree that we need pretrial support and services, and so I agree with moving forward this. I do think, and what might happen in the creation of the program is fleshed out what is the purpose and, you know, some case management and support, but I think that may be fleshed out in that sort of creation of the program. This seems like a good starting point, but like there's some more to add. And again, for me, some of that case management support is really important.
I agree that this could be the most significant change, as we finally would be supervising people with conditions of release and not asking it be haphazard around the state. I think one of the questions I had when I asked Ben to do this was, it should be DOC or should it be the court that they work for? Should they work directly for the judiciary?
Right. And the way the federal government has it set up is that they work under the Office of Probation and Parole and report to the court. So in my view, the equivalent would be DOC reporting to the judiciary, but that can be.
It seems to make sense to me, given that probation is already doing this type of supervising, that it would be housed there rather than recreating it somewhere else.
As long as it's clear that they have an obligation to the court.
Yes.
I think we might want to excuse me, we might want to make that abundantly clear that they have an obligation to report to the court.
Okay.
Well, you know, one of the things, most people who had a DUI back in the day were required to go to their local police department or sheriff's office to take a breath test daily or something like that. That's kind of gone by the wayside. Police doesn't do that anymore. And obviously, they don't get reimbursed for it, so we really don't have any supervision.
When I think too, with the backlogs, there's such a lengthy period of time without any of the, you know, people are falling through the cracks because they don't have the support and service that they need to actually maintain when it's not 3 weeks, it's 6 months.
Sorry, I missed Thursday's meeting on the judiciary positions, but I think one of the things that we have to do is set up within the judiciary the ability for them to have retired judges do and I don't know, Ben, if we should add this to this, but we should give the judiciary the ability to get retired judges to do something about the misdemeanor backlog.
So one of the things,
To hear them
yeah,
on a regular, I mean, they've got obviously, somebody that commits a serious crime is gonna go first. And there's nobody, and they've got people with misdemeanors, 2 years, 3 years old.
one of the things that came up on Thursday, and I'm hoping to connect with John Campbell a little bit more about it, what changes might need to be made to facilitate this, but someone who's been out on a misdemeanor that's 3 years old, that hasn't committed another crime, maybe we look for a pathway for that to just be dismissed. Arguably, they've served the sentence.
Yep.
And John and I were gonna connect, and
Okay,
thank you for reminding me.
That could be either part of this bill or
Yeah.
part of another. Probably more appropriate here, or more appropriate on the judiciary bill. I don't know if we have. Wednesday, we're meeting at 12:30 with Megan to do an agenda. And Thursday, we're meeting with the House. So if we can kind of talk about what you need from those two bills you took up Thursday.
The judicial positions?
Yeah.
And what was the other one again? The other bill?
For Wednesday?
No,
The
last
one that we did on Thursday.
Oh, that was the contributory negligence
Oh.
bill.
Yeah, your bill.
Yes, my
Yeah,
bill.
yeah, yeah.
Oh, yeah. Do we need anything more on that, or you just want to pass?
There are some changes that need to be made.
Okay, so we should schedule that for both those, but I'd like to bring up I don't know who's the drafter of the judicial positions.
Was that 59?
Well, Eric does the miscellaneous bill.
Okay.
Yeah,
So
it was
We should
Eric.
bring up the idea of, there really was the Attorney General's idea to have retired judges hear these misdemeanors because they're so old. Like you said, there've not been any trouble for 3 years. Or on the other hand, maybe they've been in a lot of trouble. And, you know, we should dispose of the case.
I think the only lingering question would be if, let's say it's a misdemeanor, non-violent, somebody commits theft, steals a bunch of things from the victim, what about reparations or not reparations? Restitution, that's, yeah, thank you. I think that would be one of the lingering questions as to how that would be resolved.
I think in the bills on sealing and expungement, we've always required restitution be met in order to be eligible.
Yes. So, Senator Sears, I just have a few questions as far as next steps with this amendment. Timing. Is that still being worked out as far as next week sometime? Okay.
Yeah, and then we can, hopefully, you can redraft it and send it out to the interested parties for comment.
Okay. And as far as what to draft, I kind of have a running list. Going back to the beginning, we were talking about making clear that, how, if you were released on personal recognizance, if this would capture you or not.
I'm not as interested in people who are released on personal recognizance because the judge has already made a determination.
Right.
I'm more worried about people who've been released on conditions of release.
And for congruency, I mean, if the committee wants to establish that pretrial services office, for lack of a better term, at least in the beginning on the model of what the federal government does, part of what the judge would be considering would be the report that those individuals give to them. So it kind of makes it a more efficient process, and there may not be as many concerns with those people released on their own recognizance. So
Is that constitutional?
the report, like the pre-arraignment report, or
I guess it must be if it's the federal system.
Yeah, because it's really just a requirement, it's just a report, making recommendations, but the judge doesn't have to follow the recommendations.
I thought that we could require drug screening.
Well, you can't require, I guess, treatment. You can do an initial screening, and that's something that's done as an initial condition all the time. Typically, if you have a DUI case, one of the standard conditions in the beginning would be to do a risk need screening. So that's been done.
Okay.
I think the difference is maybe you can't require treatment right out of the gate. Because what the requirement is that get the screening and then follow the recommendations of whatever the screening results are. So if you need treatment, follow that course of treatment, or if the
I
screening
can't
says,
just say get treatment based
Right.
upon.
because the
the
screening would
charge.
say you don't have a problem and you don't need treatment.
Senator
Ben, I appreciate kind of following the federal system. When we were hearing from, the former US attorney about the federal system, there were some pieces that, sort of struck me as much more heavy-handed than might be allowable under our Vermont Constitution.
Right.
Are those here, or did you sort of make the decision to pull those out?
Well, they're not reflected at all right
Okay.
now.
Okay.
As all this was the combining of the two bills with a little bit of additional language tying it to public protection to kind of divorce it from bail and the constitutional restrictions of bail. But the issues that former U.S. Attorney Nolan was talking about are not included, at least on the pretrial services side
Okay.
of this, because of the constitutional differences between us and the federal government.
Okay. Awesome. Thank you.
Just kind of continuing down the list, it was discussed to add alternatives to incarceration to the list of conditions, GPS monitoring, home detention, making it anyone eligible based on, I have a gap in my notes on that one. There was discussion on,
who's eligible?
right,
Who's,
because I think the question I had was, is that something that should be included on the list of conditions that can be imposed at the initial arraignment? Or if that's something that should be included in that list of sanctions if you violate conditions under the new procedure? Okay, so not under at a first appearance, but only at that violation hearing.
I think unless the court determines otherwise, can the court place that condition on without the screening and other?
I think that they could. There might need to be a finding that's made, and they do this with the current bail conditions. With for instance, releasing someone into the care of a responsible adult. A lot of times you're going to need testimony from that adult to say that they're going to attest to it. So there are procedures that can be.
That's one I don't particularly like.
Right, but I'm just using that as an example.
We don't define a responsible adult.
That's
There
true.
was one time that I got stuck in a situation, my wife and I had taken the kid home with us. They couldn't find a responsible adult in his family. There were none.
Well, that
Makes
was
sense then why they might have been having a hard time.
Yeah.
similar anecdote. My first bail hearing ever as a private practitioner. I had to put somebody's father on the stand, and it was a big question whether or not he would qualify because he had a criminal record himself. And it was, either be under his care or go to jail. But yeah, it can be difficult.
Yeah, we didn't. I had kind of intended that to be something that would be used upon a violation or serious violation.
So that GPS monitoring, the home detention, a form of supervised curfew.
And any other recommendations of the, what do we call them? The people in section 10.
Repeat offenders? Pretrial supervisor?
Pretrial supervisors.
Yes. Pretrial supervisor could recommend.
Okay. And then there's the pilot program,
Presumably, they would have checked responsible adults, et cetera,
right?
not leave it to the,
And then we discussed creating a pilot program, to supervise those home detainees.
well, I don't know. Let's not go pilot at this point. Let's go statewide.
Statewide, okay.
Because they can contract, I think that they're given the ability to contract with anybody,
Right, so municipalities, nonprofits, for-profits.
other states. I mean, I remember Tim Ash, when we first discussing this, Tim Ash was saying that, why not Massachusetts? It's just a big computer screen telling us where they are.
Right.
Sure they.
Okay, so I'll add other states to that list of entities as well. And then in the firearm statute, delete dispensing from subsection D and explore carrying and really what
Yeah,
that
what does
means.
carrying mean?
Okay.
Well, Eric could probably help with that.
And then as far as just getting some testimony on Tamarack and diversion from the RJ providers, DSAS, law enforcement agencies. They, a lot of times they can do sort of pre-charge
Well,
referrals.
maybe public safety.
DPS. Did we want to define repeat offender in the diversion amendment, or kind of leave that for the time being?
I don't know that we want to do that.
Strike that from, I could just
Well, I
strike
don't
that
know, where's
section.
the majority of the committee at? Do we want to limit?
I mean, if they get determined the second or third time that they're still a good candidate for diversion, it still solves or provides the advantages that diversion provides. So I wouldn't want to deny
It's
people.
basically up to the state's attorney. Isn't it?
Yeah,
Yeah, I wouldn't want to limit it either.
Well, and it's not only up to the state's attorney, it's also up to, the diversion program and to the participant themselves.
Yeah, the diversion program could refuse the person if they wanted to, right?
Right, they could say they're not
Or the-
appropriate.
So I don't know that that's necessary.
So just strike that whole section.
Mhm.
Okay,
Yeah, I think so.
and then striking the report in section 9 as well.
Yeah.
And then, with the pretrial services program, should I just draft it at least on the model of the federal program for now and then go from
Yeah,
there?
I think, honestly, there may be some opposition to this idea, but I think if we don't have somebody monitoring people, they feel they can get away with anything. And don't take the conditions of release seriously, right?
And just make sure within that,
Know that we did something similar with sex offender registry requirements. I can't remember the bill, but we put in the ability for the Department of Corrections, local law enforcement, so forth, to monitor. And what amazingly happened was most people were following the conditions, but they were now aware that they're being monitored to follow the conditions. Because I think it was part of the, following the murder of Brooke Brennan. I think that's where we did it, because there was nobody monitoring. And the evidence was that when somebody's violating conditions of the sex offender registry is when they're most likely to commit a crime. For example, they're not providing an updated address, they're not doing this, and this. And so I think we put probation, I don't know if we're still doing it, but I think we put probation, parole, local law enforcement together. We should probably look at that again, by the way. But that would be a model for,
right, I could look at that and see and,
I think
reach out to you.
Michelle probably did it.
Yeah, I'm currently working on a bill in House Human Services on child sex abuse registry, not necessarily adults, but there are a lot of similarities between the two, so I'm getting my feet wet in that department as well.
I'm pretty sure Michelle did the sex offender bill.
I'll talk to Michelle about it. And I think that does it, and I can also talk to Eric about, the retired judges.
Oh, yeah,
Mhm.
that'd be a different bill, that's in the, that's, judicial vacancy bill.
Okay.
Pardon, that's not vacancy. Additional judges. Senator?
Not opposed to that. I just want to flag in government operations, when we did a similar process for teachers, we had to deal with their pension so that they would not lose access to their pension. So it may be that GovOps or the Pension Oversight Committee needs to just make sure we're not, because I'm sure the intent is not to allow retired judges to return and thus they lose their pension benefits.
No, I think they already do return on a regular basis.
Yeah, they're, yes.
Okay, I just wanted to make sure that was a flag for me, having done a lot of pension work.
I think a lot of the, but thank you, but a lot of the retired judges are working 1 or 2 days a week. They kind of enjoy keeping their hands in it. Especially when we can check with Judge Zonay, though, no question, but I don't think there's any, I don't think they lose anything by working, maybe Social Security depending upon their age.
Well, I'll talk to Eric about it and flag the issue for him as well. And I'll have it ready for whenever this is scheduled for next week.
Yeah, I wanted to be able to hand it, to send it out to the, so they know what it is.
Right. And I'll try to have a
So-
day or two
So
early.
look for Judge Zonay, Judge Tim Waters, Dumont, Matt Valerio, the law enforcement, the state police, Department of Public Safety, what do they call it?
The restorative justice.
Yeah, so that's,
The Attorney General's office.
Yeah.
well, there's the community justice unit of the Attorney General's office, but this is the complication when it comes to restorative justice in the state,
Yeah,
is
I
that
know.
it's very decentralized. And there's no sort of unified
Is
group.
Willa Farrell still
Yeah, Will Farrell's the co-director with Eric
Probably
Jacobson.
there? Person to ask.
Yeah. But then there's Derek Miodupnik from the Department of Corrections, who's sort of the grant administrator for these programs.
Well,
And then
we're
there are
putting in positions for the Department of Corrections, we should probably have somebody from there.
And then there's the providers themselves, the boots on the ground. You know, I would say people that have testified are Heather Hobart from Lamoille County, Rachel Jolly from Burlington, Jill Evans from Essex, Letha from Bennington.
I think one would be enough.
Hey,
I think the services and supports in Chittenden County are pretty robust. I wonder if Rachel Jolly makes sense.
That's fine.
sure.
Do you have those names? And we'll just schedule them for, let's shoot for Thursday
Okay.
and having the new draft by Monday or something, send out
Okay.
to all those people. Well, that was productive. I think it was. I think we had a great discussion on that. I think it addresses a lot of concerns of the public. They may not see it that way. Everybody. I think it does it, you know, by focusing on violation of conditions of release, I think it's rather than getting into bail debates, I know.
I mean, I do still think that we should
I know.
eliminate cash bail and utilize robust pretrial supports and services. Instead, I think it'll be more effective and more in line with our Constitution and the purpose of bail.
But I don't think this is the year for that.
I disagree, given that we know that just a few hours or a few days in jail, it actually increases people's rates of recidivism and going on to commit more violent crimes. I think actually getting people out into the community with support is gonna increase public safety.
Trying to keep them out of jail by offering
Yes.
alternatives and supervision.
I know, but I think that
So
we have
it's
to
all
have.
designed to do what you want.
It
But I'm
is.
afraid this year, I just don't think this is the year for that.
I hear you.
I saw the governor stand up and say, I made a mistake.
Which I had never heard before.
No. And I think he did, but
I hear you. But I'm gonna just put on the record that I think we've got to follow the science and not just the vibes. And the science says bail doesn't do what we're trying to do.
that's been noted.
Okay.
You're on the record, and I think is there anything else?
It was a good discussion.
It's very productive when there's just 4 of us.